How do I win unwinnable cases? All right, the intake legit starts with Tori. She's gonna get them on the phone, and we have super detailed intakes that you have to go through. And the reason is, we're not leaving any stone unturned. Okay, well, it is after 5 o'clock when I'm shooting this video, so I can't be too damn mad about this. I need all the information. I wanna know it all. Anything you might think is relevant is extremely important to me. I want to know everything from the second you thought a cop saw you until the second they actually take you to the detention center and book you in. Every detail. All right, I got the intake. I don't just call you up at that point. I slide over here and I start pulling up research. It is what is important. I do what I call a preliminary research because I want to pull the statute, see if anything's changed. I want to see if there's something odd hanging out there. Most of the time, there is not. I've dealt with this enough. I can see it coming. I know where we need to go look, but I almost always pull the statutes relevant to a case before I even call the person, even if I think I know them off the top of my head. What, you don't think I know what 631130 is? It's our DUI statute. After I've pulled the statute, it's time to have a consultation. Our consultations are not quickies. You're gonna spend at minimum 15 minutes on the phone with me. That is bare bones, minimum, as straightforward as it gets. There are sometimes I spend an hour or more in a consultation. It's not always over the phone. Just in the modern day, it's gotten to where it is. When I first started practicing law, everybody came into my office and it was great. You get to know the person, shake their hand. Now I deal with so many people out of state that it's just easier for them to make a phone call and do it that way. I have a whole video on what to expect in a consultation so everybody knows how to prepare and to get the most out of it. I have some people that don't send me their documents or anything like that, and they go, oh, well, I'd like you to solve all my problems. Hell, I don't even know what you're looking at exactly. I'm guessing what your charges are based on what you're telling me, and I'm usually pretty good at it. Wow, when you give your attorney everything. Once we have the consultation figured out, the next thing we got to come to is the money. You got to pay me. You don't work for free. I assume you don't want to work for free. I know I don't want to work for free, and I do not work for free. Yes, we offer payment plans. There's a contract involved. There's invoicing involved, all that good stuff. And the second you sign the contract and you make the initial payment, it's when I start rocking and rolling on your case. Because we're going to file a flurry of documents in the beginning of a criminal case, especially a misdemeanor one. Not so much necessarily in a felony one, depending on the person's been indicted or not. Even if they have been indicted, the arraignment's all you really got to take care of out the gate and file your request for discovery, generally speaking. We also file a notice of demand for speedy trial. Almost never comes into play, but almost is that key word. All right, so you've paid me at this point. I have filed everything, and I start getting documents back. The next part is my discovery deep dive. That is where I go through every bit of discovery. I might have 6 30-minute videos. They all cover the same 30 minutes, but you figure it's Officer 1, 2, and 3's body camera, and then you throw in their dash cam. I'm gonna watch all of them. I'm gonna listen to all of it. You never know when an officer's gonna say something dumb that, at the very least, you can use it for you in your case. The best, it might make your case. Now, we started out with unwinnable. We hadn't gotten to winnable yet, but this is the part where we start at it mostly, is that discovery. Because again, you never know when you're gonna find a diamond in the rough. Maybe one officer said something that's just completely wrong. I start at the very beginning. I'm looking at the probable cause. Was there probable cause for the stop? Looking at the totality of the circumstances? Nope. It's gone. Also, more on probable cause here. In Mississippi, they have what they call a community caretaking function. That's a real pain in the ass, because if they believe that there's an emergency, they have a right to stop and help, things along those lines. Watch it. Some folks get tied up watching these auditors and stuff like that, and they're sort of right a lot of times. Sometimes they're not so much. After I've dug through the probable cause, I go and make sure the police officers have followed all the procedures. Once I get through the procedure part of it, then we're down to arguing facts. And I've just told you everything in the order of importance to me in a file. If I am down to arguing the bare bones facts of a case in front of a justice court judge, we're probably in a bind. I don't want to get down to there. I start with probable cause. Somebody on one of my shorts got on to me and said, why wouldn't you go argue the case? Why are you going to argue probable cause? Cut off the head, the rest don't ride along. If I can stop it right there, we're done. We walk out. My client's happy. I've earned my fee. And what's more, justice has been served. His rights or hers to due process has been followed. It's that simple. Works that easily. Now, past that, we start digging off into procedures. If the police didn't follow the proper procedures, have the proper certifications to do something or operate a piece of equipment, think of an Intoxilizer 8000, then you have a hell of an argument to get that evidence tossed. That's exactly what we're looking at. Or maybe you get the officer's certifications or training records and you find out that on the date that this occurred, that officer didn't have DUI training on standardized field sobriety test. Damn hard to argue that your field sobriety tests were done correctly when you were never trained on it. So I'm looking at all these things and tearing them apart piece by piece. And keep in mind, at the same time, I'm back over here researching these little pieces that I keep finding to see whether or not I have a hole I can walk through, or my client can walk through, whichever way you want to look at it. Then I get down to the facts. The facts are quite often the hard part to get around. That's why I put it at the bottom of those three things. Get your probable cause up here, then I'm down here arguing procedures, and then we're down here arguing the facts. I want to get it knocked out at one of these up here. When I go into court, I may have found a half dozen or more things wrong with the case. Usually it's nitpicking for some of it, that it's not going to get anywhere, it's going to be harmless error, which is a phrase I hate. I disagree with harmless error. Either you followed the process or you did not follow the process. What I want to put in front of a judge or a jury is 2, maybe 3 key errors, issues, whatever, that win the case for me. One of them is like tightrope walking without a net under you. I don't want to do that. More than 3, it gets pretty confusing. You're not going to get a jury in Mississippi on a DUI first offense unless you got a child endangerment. You're not even going to get it on a DUI second offense without a child endangerment. So you don't have a jury. So you got a judge that has a full docket that they want to run through and get past it. So you can go and hang up on every little detail. And some of you may be saying, well, that's exactly what I want my lawyer to do. It's exactly what I want. Getting stuck in the weeds is the last damn thing you want your lawyer doing. Your lawyer better be reading the room the entire time they are arguing your case. If they're not, you're going to get the shaft. Don't want that. Let us do what we've been trained to do and what we've learned. Let me take my 2 or 3 things and go hammer on that, because a judge, 2 or 3 things keeps their attention really well. Think about you, for example. If I told you I am going to go and file a entry of appearance, motion for discovery, notice of demand for a speedy trial, a motion for a trial within 30 days, or an alternative to extend my client's driving privileges. Or if I just told you you need to focus on probable cause, procedures, and facts. Which one of those do you remember? Bet you remember probable cause, procedures, and facts. It's the same concept. You're looking at the path of least resistance. I want them to remember what I said. I want them to comprehend it. Give them 20 things in their head. It's anybody. So that's what I'm doing when I am focusing in on an unwinnable case. I am trying to find 2 or 3 points to either waller out or hammer home, just depending on which way it goes. Does it work? Not always. It started out with something I thought was unwinnable. Hell, you sure thought it was unwinnable when you walked in my office. But it provides the greatest chance of success of winning a case. There are elements of luck out there that I can't control. Maybe the police officer moved to Montana. They ain't coming back here for your DUI. I promise you. The state of Mississippi don't want to pay them. They ain't coming. You just got lucky. Maybe the state commits a discovery violation, and that's what gets something tossed. All possibilities. I wouldn't hang my hat on it. So there's a factor of luck out there, but there's some good lawyering, some solid lawyering. And remember, I'm a lawyer. I'm not a magician. Just because you hired me doesn't mean it goes away. It means I'm going to give you the best fighting chance to make it go away, to find you not guilty, to get the case dismissed, non-adjudicated, whatever it is. On my intake form, I ask you, what are your goals with this case? You just want to stay out of jail? Want to keep it off your driving record? Do you need the case dismissed? Trying to keep it off your insurance? I want to know what your goals are on the head end of things. So that's factored in the entire way with your case. So, if you've enjoyed this, like it. It means a lot. It means even more if you subscribe. If you got a comment, tell me. Something you want to hear about? There's a couple of people that have said some things, and I've actually got some videos in the works on those. I need to get them edited up and get them out. So I'm not ignoring the comments at all. If you have something you want to hear about, I'm going to do my best to get it out to you. If you have thoughts on this, questions on this, let it out there. If you think that all criminals should just go to jail because somebody wrote them a ticket, tell me about it. If you think there's not a guilty person out there, tell me about it. If you believe that there is some middle ground, let me know. Hope y'all have a great day.